All right, Your Honor, we are ready. Mr. Adams?
All right, who are you ready on?
Mr. Adams is ready.
All right, Mr. Adams, you ready on Mr. Copeland?
Yes, Your Honor. Mr. Copeland, Rusty Copeland.
All right, CR 23-93, State versus Rusty Wayne Copeland, pre-trial. Go ahead, Mr. Adams.
Yes, Your Honor. As the court may remember, Mr. Copeland was indicted for the case that's before the court today, subsequent to a jury trial that we had for him back in the springtime. I've got a plea offer from the DA's office. I have not reviewed the discovery yet with Mr. Copeland, though, for this new engaging case. And so I'd ask the court to reset us for a subsequent pretrial setting, so that I can do that, go over the discovery with Mr. Copeland. And I'm afraid, Mr. Hartwell, I'm going to have to visit with you about your plea offer.
All right.
So, upshot is, may I have another pretrial, please?
Can we set it for November 28th? Or actually, you had a conflict on the 28th, didn't you?
I do, Your Honor.
We can make it earlier. We can do that. I think you set your other one on November 9th.
But that's in the morning time, I think, and I don't want to be here all day. No offense to you, but I can't make much money over here. Checking.
What about November 7th? Yeah.
I'm already on that afternoon docket, so that would be fine.
Okay. Court sets Mr. Copeland for pretrial November 7th at 1:30.
All right, Your Honor. That's all the business I have for you this afternoon.
Thank you, sir. Yes, sir. Appreciate it. Mr. Smith, who are you ready on?
I'm ready on Amber Smith.
Ms. Smith? This is CR 20-367, State versus Joe Smith. Is this a plea today, Mr. Schmidt?
Yes, sir.
All right, let me go over the plea here. Make sure we have it right before going further. This would be a motion to revoke in which Ms. Smith would be pleading true. Appears to be all counts. State's recommendation is that supervision be revoked, punishment be assessed at 2 years confinement. Texas Department of Criminal Justice balance for financial obligations. She would receive 268 days credit towards her sentence for time served, and that would be on a 3rd-degree felony prohibited substance or automatic corrections.
That's correct. That's our understanding of our agreement.
All right, Ms. Smith, if you'll raise your right hand on the conviction of oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help me God? All right, you can lower your hand. Just make sure you speak up loudly and clearly. Ms. Smith, the state has filed a motion to revoke your community supervision. They did that on what appears to be June 1st, 2023. The court had appointed the Honorable Richard Schmidt to represent you. Do you feel like you've had enough time to talk with Mr. Schmidt about your case to the point that you've had all of your legal questions answered and that you fully understand everything that you've read and signed here today?
Yes, sir.
All right, Mr. Schmidt, do you believe Ms. Smith to be confident in entering into this plea agreement?
Yes, I do.
Do you believe that she's doing so intentionally, knowingly, and voluntarily?
Yes, sir.
All right, Ms. Smith. Mr. Schmidt, does Ms. Smith waive the formal reading of the state's motion on vote?
We do, Judge.
All right, then Ms. Smith, I'm going to ask you then, how do you plead to counts 1 through 13 as alleged? Are those counts true or not true?
True.
And you're telling me that each one of those counts was true because, in fact, the information contained in those counts is true. You're not just saying that to get a plea agreement. It's all correct.
Correct.
All right, court will accept Ms. Smith's pleas of truth to each count as alleged. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights to plea of truth?
No objection.
All right, that is submitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Anything from the defense?
No, sir.
All right, and based on the evidence before the court finding that Ms. Smith has pled true to all counts, the court finds that all counts are true, that Ms. Smith has violated the terms and conditions of her community supervision. The court follows the plea agreement today, revokes Amber Jo Smith's community supervision, sentences her to 2 years confinement in the Texas Department of Criminal Justice on the charge of prohibited substance or item in a correctional facility, a third-degree felony, or towards her to pay the balance of the financial obligations, and awards her 268 days towards her sentence for the time that she's already spent in jail. Ms. Smith, you are remanded to the custody of the sheriff, so we can carry out the terms and conditions of the sentence. When you get released from TDC, make sure you report to the courthouse to make arrangements to pay off your fines, court costs, and restitution. Okay? All right, good luck to you. Step over to the deputy to move here. Who's next, Mr. Smith?
Alexis Stevens.
Alexis Shea Stevens, CR 23-102 for pretrial. Go ahead.
Judge, we don't have any contested pretrial matters. We'd ask that this matter be set for a plea this Thursday on 10/26.
All right, court will find that there are no contested pretrial motions. We'll set Ms. Stevens for plea on October 26th at 1:30. Who's next, Mr. Smith?
Oh, Villarreal.
You said Raul Villarreal.
Correct.
All right, this is cause number CR 23-80. Is Mr. Villarreal going to be entering a plea today?
Yes, sir.
It appears that that is to a lesser included offense, assault causes bodily injury, class A misdemeanor with punishment after 49 days in the county jail, credit for all 49 days of time served. Fine of $500, court costs $270, reimbursement fees $585. Does that sound right, Mr. Smith?
Yes, sir.
All right, Mr. Villarreal, if you will raise your right hand, I'm going to place you on oath. Sir, you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help me God.
Yes, sir.
All right, Lord, again. Mr. Villarreal, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a type of mental condition?
No problem.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt's work?
No problem.
Feel like you've had enough time to talk with him about your case? You've had all of your legal questions answered, and you understand everything that you've read and signed in your plea agreement?
Yes, sir.
Mr. Schmidt, do you believe Mr. Villarreal to be competent, and if so, that he entered into this plea essentially knowingly and voluntarily?
I do on both counts.
All right, then, Mr. Villarreal, you were originally charged. What was the original charge, Mr. Schmidt? I don't have comments of the indictment.
Which was engaging in organized criminal activity. The underlying act, conspiracy to commit assault.
Okay, thank you. All right, Mr. Villarreal, originally indicted with engaging in organized criminal activity. The proposed plea today is to a class A misdemeanor, which carries a range of punishment of not more than 365 days in jail, county jail, or a fine not to exceed $4,000. You've heard the court read the plea agreement. Is that your understanding and what you're asking the court to approve?
Yes, sir.
All right, Mr. Villarreal, how do you plead to class A misdemeanor assault causes bodily injury?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Anyone threatened, force, or pressure you to plead guilty?
Yes, sir. Well, excuse me?
Has anyone threatened you, forced you, or pressured you to plead guilty today?
No, sir.
Okay. Court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to stipulation of evidence in this clause?
No, sir. We provided with a written stipulation of evidence, which myself and Mr. Villareal signed off on, it's in the packet for the court.
All right, the court will admit the stipulation of evidence, into evidence. The court takes judicial notice of the defendant's judicial confession. The court accepts his plea of guilty at this time. See anything further from the state?
No, Your Honor.
Is there any victim compliance with notification on this trauma violence?
Your Honor, let me double check and make sure if the court will give me just a minute.
Yes. Mr. Schmidt, while we're waiting, Mr. Burwell, I do not have a copy of the stipulation of evidence. Do you have one with you, sir?
I do. Would you like me to recite that for the court?
Yes, sir, please, if you don't mind.
On or about December 3rd, 2022, in Van Zandt County, Raul Villareal was with Johnny McMinn and several other individuals. Mr. McMinn hired Mr. Villareal to recover items that Sean Van Dyke had and was supposed to have sold from Mr. McMinn. I went to First Monday in Canton to confront Mr. Van Dyke. During the confrontation, Mr. Villareal struck Mr. Van Dyke from behind.
And Your Honor, I did confirm with Melissa, our victims services coordinator, that we are in compliance.
What does that mean? Does that mean that you sent a notice, or that the victim is supportive or not supportive, or?
That there was no response, Your Honor.
There's no response. Okay, thank you. All right, then based on the evidence before the court finds that there is sufficient evidence to convict Raul Villareal of assault caused bodily injury. The court follows the plea agreement today. Court convicts him of the class A misdemeanor offense, assault causes bodily injury, assesses punishment at 49 days confinement in the county jail, issues credit for 49 days of time served, assesses a $500 fine, reimbursement fees of $585, court costs of $270. Mr. Villarreal, whenever you get out of jail, when you're released, I want you to report to the district clerk's office here at the courthouse to talk to them about paying off your fines, court costs, reimbursement fees. Failure to pay those things as ordered will result in court issuing a warrant for your arrest. And we'll go back through this process. Do you understand?
Comprehension today?
Sir, you made it in. Mr. Villarreal, you hereby remain into the custody of the sheriff, so you can carry out the terms and conditions of the sentence. Step over with the deputy. If you Mr. White, who are you ready on?
I got Mr. Green.
Holton Castle Green, CR 20-303, docket call, but Mr. White.
Your Honor, we're gonna ask the court to set the plea on, Thursday afternoon.
All right, court sets Mr. Green for plea October 26 at 1:30.
Your Honor, that's all I have.
Thank you, Mr. White.
October 30th.
Thursday.
Oh, Mr. Mulder. How are you, sir?
I'm well, Judge. How are you?
I'm doing well. So good to see you.
Good to see you.
You're here on Carl Caver, is that correct?
That's correct.
Mr. Caver, come on up. This is cause number CR 21-380, CR 2289. I show Mr. Caver set for pretrial in the Agasol case and arraignment on the bill of being failure to appear. Have you had an opportunity to review the indictment with Mr. Caver on the bill jumping?
We have.
Are you ready to proceed on that?
Yes, sir. We'll waive formal arraignment.
Okay. Did it name spelled correctly in the indictment?
I'll check that. Let's see. Yes, sir. That's correct.
Okay, there's a plea of not guilty.
Yes, sir.
All right, we'll find Mr. Caver has waived formal arraignment. Enters a plea of not guilty. The court will enter that into the record. Let's see, so I can reset both cases for a pretrial unless you're ready for an announcement on pretrial on the Axel case. Or have any discovery issues.
Yeah, I don't think we're having any issues at the moment, but could we set up for one more pretrial so I could continue negotiating with them about this new case along with the old cases?
Yes, well, what I can do is I can set both the pretrial, or if you think that you won't need a pretrial hearing on the bill jumping, I could just set it for docket call and give you all time to try to work it out. If y'all can, then I can set up a trial then. Set it for 30 days or so.
Yeah, the 28th, I think, was that an option?
That is an option you available on November 28th.
Yes, sir.
Right, let's do that. We'll set both cases for docket call on November 28th. Have one that if Mr. Caver makes bail, then his case will be same day at 9.
Understood.
All right. So y'all both back on November 28th.
Great. Thank you, Judge.
Welcome. Good to see you.
Good to see you.
Your Honor, we request for about 5 minutes.
5 minutes is granted.
Richard is talking to the others, and then Mr. Weiner is waiting on plea papers.
Yes, ma'am. No problem.
Your Honor.
Yes, ma'am.
We're ready.
Who's that?
Crystal.
You said this is Mr. Wilson.
Correct.
This is Preston Mitchell Wilson, CR 23-83, pretrial vote, Mr.
Judge, at this point, we've been passing pretrial. We had expectations that some of these charges that are filed against Mr. Wilson were going to be submitted to the United States Attorney's Office. It's my understanding, based on speaking to Detective Wheeler, that Mr. Wilson has been indicted by a federal grand jury as of, I think, like 2 weeks ago. So I've reached out to Ms. Curry and Mr. Hartwell to see if we can't confirm that, and then try to determine how it's going to affect ongoing prosecution here in Van Zandt County. I don't have the answer to that, but from that perspective, I would ask that this be pushed off for an additional pretrial. I suspect that we'll have an answer pretty quickly, and Mr. Hartwell may be able to speak to that.
Yes, Your Honor, I've started to look into that. I don't have a final answer yet. But I've begun checking into the status there.
Okay. We should need 30 days though, correct?
Right, Your Honor. I expect we would know before then.
Can we just set it to November 7th or 9th, so we're not?
So I won't be in town on those dates,
You said you will or won't?
not be available on the 7th or the 9th.
Well, that's on the 28th then. And so you need a pretrial or a document?
Pretrial, please.
All right, court was set for pretrial. November 28th I'm sorry, 1:30. Who's next?
This is Brian Morris.
Brian Anthony Morris, CR 14.20, motion to revoke, go ahead.
Judge, we're in negotiation. I think the court is aware that Mr. Morris was in Kaufman County, then he was in Van Zandt County, then he was pulled to Smith County or back to Kaufman County. He hasn't been in our facility long enough for me to meet with him more than 5 minutes on one day. I have been negotiating with Ms. Curry on a resolution on his case, but we're not quite there yet. And most of that is due to somebody else coming and snagging him up before I get a chance to talk to him. So we'd ask for a reset on that. And I don't know when the next contested TA docket is, but
Next contestant is on Thursday of this week. After that, it'll be November 30th.
could I have November 30th, Judge?
All right, court will set Mr. Morris for contested hearing November 30th. And court will order that Mr. Morris not leave Van Zandt County custody.
Or November? Well, yeah. William Petty?
William Lynn Petty, CR 16325, or motion to revoke. Go ahead.
Judge, I'd ask that Mr. Petty be set for a plea on Thursday.
All right, court sets Mr. Petty for plea on Thursday, October 26th at 1:30.
Jeremy Hester.
Jeremy Wayne Hester, CR 21291. Mr. Hester said motion to revoke the leave.
I don't think that's correct, Judge. I think it would have been on a docket call. Yeah, we're on docket call. I don't know what it's broke up in there. Perhaps I checked the wrong box last time. He's been carried on a docket call. And I think the last time we were in court, the court admonished us to the number of docket calls that it was going to tolerate. Didn't give me a number, but kind of hinted that their court was getting tired of messing with it. But long story short, been dealing with Ms. Curry on Mr. Hester's business, and it requires the participation of law enforcement at the sheriff's office. It's my understanding that the individual we were dealing with has been out sick for the last couple of weeks. I saw him today, so he's back in business, and I've notified Mr. Hartwell and hopefully Ms. Curry so that we can get this moving and get Mr. Hester on track, hopefully sooner rather than later. So theoretically, I'm asking for an additional docket call.
I think what I would rather do is just set him for trial. That way, if there's no movement, we don't push the trial out much further due to the number of docket calls. I don't know what to do. This case is language. I don't want him languishing in jail. I don't have a deadline. If y'all come up with some kind of agreement, let me know, and I'll create an exception to my policy on no pleas after docket calls, since you're waiting on state or law enforcement to cooperate with you. I think I'd rather just go ahead and put him on the trial.
Sounds good, Judge. That'll work.
All right.
Okay, 30th.
We'll set it for October 30th. That way you'll go ahead and get this place held on that date. All right, who do we have?
This is Ryan Augenstein. 1276 and 20.
Ryan Augustine, CR 21-276, special pretrial.
That's correct, Judge. I've also made numerous appearances on CR 2343. I wasn't retained, but we'll handle that one as well. If the court needs me to file a formal appearance of counsel, that's fine. But for today's purposes, it appears though we've already done an arraignment on that newer case on his behalf, and ultimately it is also set for a pretrial.
Okay.
On both of those cases, we don't have any contested pretrial motions that need a hearing. We'd ask that they be carried together for a docket call.
Okay, the court will set Mr. Augustine for docket call November 28th. Each case.
Right, we're down to waiting on the 2:30 Spanish interpreter and plea papers.
What about Mr. Oh, okay, I see, Mr. Cass, that the motion. Continue as granted.
Remember, we set him on December first, which is a Friday.
So Mr. Mitz is not in there, right, correct?
No, sir, he said his attorney had sent him a letter that he was set December first.
Okay, good, excellent, okay, all right, we're gonna get their paperwork together.
When you see the Spanish interpreter, we're ready, but,
I'll be monitoring that.
all right, thank you.
Aquí al frente de la computadora.
Good afternoon, Mr. Montenor. How are you, sir? Hey, I'm doing great. Does it look like interpretation is set up correctly on your side? Next.
Hey.
Okay, are we gonna be able to see Mr. Sosa on camera? We should just be able to turn his laptop on. All right, Mr. Montemayor, if you'll raise your right hand, go ahead and swear you in. And if you'll state your name and your license number at this time. Sir, do you solemnly swear or affirm that you will make a true translation of the statements of the court, questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so let me go. Thank you, sir. All right, this is cause number CR 23-132, State versus Josue Sosa. Set for pre-trial today, Mr. Schmidt, any announcements?
Yes, Judge, we don't have a custody trial, at this time. This be carried to the other co-defendants in this case. I've spoken with Mr. Sosa and kind of explained to him our plan is, he understands that, and we're ready to proceed with docket call.
Okay, so just so I'm clear, so no contested pre-trial motions carried to the 28th docket call.
No, sir, I was asking for that December 12th date.
December 12th, okay.
Yes.
All right, so Mr. Sosa is a co-defendant of the other four gentlemen that were on the court's docket.
That's correct.
Okay, I understand, thank you. All right, court finding there are no pre-trial motions, sets this for docket call on December 12th. That will be at 1:30, so long as Mr. Sosa is in jail. Mr. Sosa makes bail, his court date will be the same day, but it will be at 9 a.m. And Mr. Montemore, before you leave, can you ask Mr. Sosa if he has any questions before? All right, great. Then we'll see him back on December 12th. All right, thank you, Mr. Montemore. I think that was short and sweet today, huh? If you can only be so lucky every time. All right, well, I appreciate you helping us out today. Have a great day.
Good, probably 10 minutes, they're warm off the press, not necessarily hot off the press.
No problem. Yeah.
Okay.
No problem. 10 minutes is fine.
I didn't have the stipulation. Wanted to put the email that to me.
And then I will.
Your
let-
Honor.
I'll let them know. Why you're waiting for the information.
Has to go back to second time, judge time. Back up. But that won't take- We go straight back, so.
Surrender. Yes, Your Honor. If you have any questions, just. What time y'all open in the morning?
7 a.m.
You gotta be there. Since we're gonna, yeah, wait. I have had people that then file on for not showing up. Be there on the door, so, yep. So, okay, it'll give you a ticket for that. You have to report that to probation. Right. Yeah.
All right, this is cause number CR 20-326 and CR 20-239, State versus Johnny Jude Jr. And Mr. Weiner is understanding that there's a plea in this case. Is that correct?
Yes, Your Honor, we appreciate your patience, the probation plea, so thank you for waiting for us to get the paperwork finalized and signed.
Okay. What are the terms of the agreement?
He's going to be. He'll be sentenced to 10 years confinement and he'll be probated for 10 years. He'll be placed on probation for 10 years. There's a substantial amount of restitution, an amount of $6,650 that will be a condition of his probation as well, Judge.
How much court costs? $290?
I apologize, Judge, for that judgment. $290, yes, sir, and there's a reimbursement fee of $105. I think that may have been because of a warrant. There's also a failure to appear that's being $12.45.
Okay, so this is going to be in cause for CR 2239. That'll be the plea on the exploitation of child locally disabled.
Yes, Your Honor.
All right, and then 1245 on CR 2326.
And for that cause number, I'd be willing to bet you're right.
That's the Belgium.
Yes, Your Honor.
All right, Mr. Cooper, if you'll raise your right hand, I'll place you under oath. Sir, do you swear that the testimony you give in court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can go ahead. Your name is Johnny Jude Cooper Jr., is that correct?
Yes, sir.
And Mr. Cooper, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Justin Weiner. Are you pleased with Mr. Weiner's representation?
Yes, sir.
Feel like you've had enough time to discuss your case with him, have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today, Mr. Cooper, that you do not understand?
No, sir.
Mr. Weiner, do you believe your client to be competent? And if so, do you believe that he is entering into this plea agreement intentionally, knowingly, and voluntarily?
I do, Judge.
Okay, Mr. Cooper, you are charged by indictment with a third-degree felony offense of exploitation of a child, elderly, or disabled individual that does carry a range of punishment of not less than 2 years in prison or more than 10 years in prison. It also carries a fine, if imposed, of not more than $10,000. I see the plea agreement in this case is that you would plead guilty to that crime. In exchange, the state's recommendation is that upon your plea of guilt, you be sentenced to 2 years confinement in the Texas Department of Justice. With that sentence being suspended, you're being placed on 10 years of community supervision, also known as probation. Zero fine, I'm assuming. Restitution in the amount of $6,650, $290 court costs, and $105 reimbursements. Is that your understanding of the plea, Mr. Cooper?
Yes, sir.
That's what you're asking the court to approve.
Yes, sir.
All right, then, Mr. Cooper, then I'm going to ask you, how do you plead to exploitation of a child, elderly, or disabled individual, a third-degree felony?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Mr. Cooper, has anyone threatened you, forced you, otherwise pressured you to plead guilty to this crime?
Oh, sir.
All right, court will accept the defendant's plea of guilt. Mr. Weiner, any objection to the mission of the stipulation of evidence?
No, Your Honor.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
None, Your Honor.
Is there any victim compliance or victim notification issues on this type of case?
I'm sorry, I didn't mean to jump ahead of you, but she's actually deceased. I've gone over extensively with my client that there's obviously a potential trial strategy on that. However, there are multiple unfiled and unindicted cases with live victims that the state could make moving forward, which is why we're going forward with this plea bargain.
And Your Honor, a victim impact statement had been completed. My understanding is that was forwarded to the court. If you need, I can take a second here to make sure that that's been forwarded to you.
Yeah, I do not have victim impact statements.
Your Honor, I received it while I was out here,
Okay, and
so I'll print it.
do you have it in email? How did you receive it?
I received it from Melissa in the email.
Can you just forward that email to me? On your phone? Do you have it on your phone?
Yes, sir.
Or can you have Melissa forward it to me, Mr. Hartwell?
Yes, Your Honor.
I'm sending it to you right now, Your Honor.
Well, I'm waiting on that. Anything further from the defense, Mr. Weiner?
No, Your Honor.
Are there any other 1245s of those unfiled cases that need to be on the record, or is that just a rejection and separate? Agreement?
My understanding is they're going to be rejected. There's nothing done formally as far as a 1245 letter, Judge. Thank you, though, for checking on that.
Okay, thank you, Patty. I do have it. All right, court has reviewed the victim impact statement. That's within the case. All right, I don't have any of the plea papers, so I need someone to recite the stipulation of evidence word on the record.
Mr. Weiner, did a stipulation get sent to you, or do you need to just give a recitation of the facts?
The stipulation's about to be pulled out.
Oh,
Please state. May I proceed, Judge?
Yes, please.
It says, comes now the state of Texas together with the defendant and his or her counsel and stipulate to this honorable court that the following facts are true and correct and could be proven during a trial of this matter beyond a reasonable doubt. From on or about June 23rd, 2020 through July 1st, 2020, I engaged in an attempt to defraud Mary Robertson, who was an elderly individual. I did so by convincing Mary that her roof needed repair and that I could do the work for her. Ms. Robertson wrote me checks exceeding $10,000. I did some minor patchwork to the area of that roof. I know that the price that I charged Ms. Robertson far exceeded the value of the work I did. The total amount of loss for my actions was $6,650.
Thank you, Mr. Wine.
Yes, sir.
All right, then based on the evidence before the court finds that there is sufficient evidence to convict Mr. Cooper of this offense. Court will follow the plea agreement based on the recommendation of the state. Court hereby convicts Johnny Jude Cooper of exploitation of an elderly individual. Assesses his punishment at 2 years confinement in the Texas Department of Criminal Justice Institutional Division. Suspends that sentence and places him on 10 years of immediate supervision. Orders him to pay restitution in the amount of $6,650. Court costs in the amount of $290 in reimbursement fees, the amount of $105. Court also dismisses under section 1245, cause number CR 20-326, bail jumping failure to appear in 30. Mr. Cooper, you hereby remain into the custody of the probation department so they carry out the terms and conditions of the sentence. I'll have you step over with the deputy to be fingerprinted, and the probation officer can tell you about what's.
Yes, sir.
All right, anything further, Mr. Swanner?
Mayor, thank you. That's all I have.
Yes, sir. Thank you. Good to see you.
Thank you.
Ms. Burns needs to speak to Mr. Hartwell.
Mr. Hartwell, on the probation referral, the restitution victim is the deceased lady. That and I don't know who that goes to.
Yes, so the victim in the case was a Mary Robertson. I'll look into seeing exactly how restitution should be dispersed.
Thank you.
And there is, I think there is information on the victim impact statement that could be helpful.
Yeah, I'll fix your dad. Yes, I got that too. Yeah, sure thing.
I'll leave it by, so.
Thanks, Patty. Sorry to keep you late.
Oh, that's okay. Okay, Your Honor, we're going back.
Okay, nothing further then, right?
No, sir.
All right, we'll adjourn for the day. Thank you.